And everybody was asking after the acquittal, well, what if they find more evidence? What if he winds up telling us that he did it? What if he confesses? You cannot be charged again, even if you come out and say, I did it. Hello again and welcome. It's Lana Manitta with Ross & Law Firm, and I'm here to talk to you today about double jeopardy. I'm going to talk about it sort of in the context of federal cases because that's really where my concentration lies. But double jeopardy is a constitutional issue. It comes up in state court. It comes up in federal court. Before we get started, I want to remind you to like and comment on this video and subscribe to our channel. We try to provide a variety of really interesting videos on different topics related to criminal defense. So what is double jeopardy? And I think this is something that a lot of people sometimes misunderstand, but the basic concept is that you cannot be put in jeopardy. You cannot be twice or more than twice forced to face prosecution for the same offense. And so there are, it's pretty broad, but it's also pretty limited. So I'm going to try to explain examples of when it would apply and when it wouldn't apply. So if you are charged with an offense in court, in state or federal court, you can't be charged with or convicted of the same offense twice in the case. And so the court will look at whether there are lesser included offenses that you have been charged with that overlap with each other. And the test basically is to see whether each offense has at least one element that the other one does not have. Okay, that's how we decide whether they're different. And when you have a lesser included offense, it's usually missing one element that the bigger offense has, but it doesn't have any elements that the bigger offense doesn't have. And so it is absorbed or merged into the greater offense. So for example, you can't be charged with robbery and assault if it's arising out of the same robbery, because robbery, requires some assault to be a part of, it's an element of the offense, okay? So that's one example of double jeopardy. That's within the same case being twice forced to be put in jeopardy or face prosecution for the same activity, okay? The other way it comes into play is if you have been acquitted of a charge and then they try to charge you with it again, or if you have been put in jeopardy by going to trial on a charge and the case is dismissed for different reasons. There's a mistrial, there's a dismissal with prejudice, what have you, and then they try to bring the charge again. Jeopardy attaches in a criminal case either when the jury is impaneled or when the first witness is sworn in at a bench trial. And so that's when, your right to not face those charges again arises. However, there are exceptions to that rule. And one of them is if the case is dismissed by the court by a judgment as a matter of law, it's possible that case might come back because, the court might consider that jeopardy hasn't really attached. And so this gets into a lot of complexities of either the state jurisdiction that you are facing jeopardy in or under federal double jeopardy law. I mean, this is basically a constitutional guarantee that you are not going to repeatedly face prosecution for something that either you're in prosecution for or you have been acquitted of. And this is why I think the big example was, we saw the OJ case and everybody was asking after the acquittal, well, what if they find more evidence? What if he winds up telling us that he did it? What if he confesses? Which, of course, he didn't do except in a hypothetical book that he wrote. No, the answer is no. He could not have been prosecuted again. And that goes for anybody. If you are acquitted of the conduct, you cannot be charged again, even if you come out and say, I did it. Now, there are scenarios where you might be charged with an offense in state court and then be charged in federal court for the same conduct, because this is going to be two different statutes, and there are going to be elements in the different statutes that do not appear in the other, just often by virtue of the fact that one comes under federal jurisdiction and so has within it some element that it was, it affected interstate commerce, or it involves a Schedule I narcotic or something like that. Whereas in the state statute, it's going to require that it, occurred in the Commonwealth of Pennsylvania or in the state of Florida or something like that. So sometimes just by definition, a state offense is going to differ enough from a federal offense that you can actually face jeopardy, face charges for the same conduct in federal court and state court. This is often something that we argue about. Pretrial, we'll still make the argument that it's double jeopardy violation, that it's not fair. Judges don't love it. It's a situation where you might be likely to get a pretty good resolution from the prosecution, if that's the case, because judges, even if they have to allow it because it technically doesn't violate the double jeopardy clause, they're going to make the government's life difficult through the prosecution. They're really not looking to pile on. And, conceivably a judge could see it as a waste of time if somebody's already faced prosecution and, for instance, wasn't acquitted in state court and they were sentenced or put on probation or paid fines or what have you, and now the feds are going after them, usually for some reason to put pressure on them to testify against somebody else, not because they really need to be prosecuted twice for the same acts. So, it's not something that judges look upon favorably, but it's something that absolutely is permitted. And so it's something that if you or someone is charged with an offense that you think was addressed in a prior prosecution, whether it was an acquittal, whether it was resolved by a plea, or it was dismissed without prosecution, this is something that you want to talk to an experienced criminal defense attorney about to determine whether or not double jeopardy actually is going to apply to this situation. And if it is, how to use it to get the charges dismissed. If it doesn't apply, then how to use it to maybe wrestle some goodwill out of the judge because it's, close, but not quite, or negotiate something with the government because it's sort of just doesn't feel right to prosecute twice for this kind of for this situation. So it's important that when you're dealing with any kind of complexity, any kind of unique feature to your criminal case, you're making sure that your defense counsel knows what they're doing and is familiar with not just the statute that you're charged with or the courthouse that you're charged in, but these sort of constitutional issues that might arise in your case, like double jeopardy. So we here at Rawson Law Firm have experience with cases that touched upon double jeopardy. We were able to let a client know whether they really have an issue or they don't, and whether we can still make some hay with it, as it were, and use some sort of complexity in the case to their benefit. So if you're facing something like this, or somebody who's facing something like this, please make sure to get in touch with Rawson Law Firm. And as always, thank you for watching. Make sure you like and comment on this video and subscribe to our channel.